I'm really glad you could join me today. My name is Michael Kruse from Kruse Law Firm, and I'm here today to talk to you about a critique of the Canadian, or at least Ontario, criminal courtroom remand system. And this involves the Ontario Court of Justice and the Superior Court of Justice. One thing that the COVID-19 pandemic has highlighted is that our remand system, our case management system in our criminal courts, is completely outdated. It's like a 19th or 20th century anachronism. There's no need for it, and I'll basically explain it very briefly. In our court system, you get a first appearance that might be 3, 4, 5, 6 weeks after you're arrested, and you show up, or your lawyer shows up and says, look, this person's retained me, and I need 3 or 4 weeks to report to the Crown Attorney and speak to the Crown and get disclosure. It's a completely useless system. It's just a reporting system. You have to go back every 3 or 4 weeks and say something along those lines. Look, I need more time, or I need to set up a pretrial with a judge, or a Crown pretrial with the Crown. Why do we need this system? We don't. COVID has highlighted this because our cases are currently going over automatically. You don't even have to attend. It's presumptively that they're going over. And what's that said to us is, look, we can still do the normal steps. We don't have to report to a justice of the peace every 3 weeks. We can just report those steps electronically. You're expected to do certain steps. And why do we have to keep going back to court like this? I would expect, I really believe that there's a very good chance they're going to completely scrap our remand system, both at the Ontario Court of Justice level and the Superior Court of Justice level. Superior Court of Justice is called assignment court. Again, it's useless there, in my respective opinion, and there's other ways and means of doing it. For example, defense counsel and Crown counsel could just be expected to complete the normal steps in, say, 3 to 4 months, and send an electronic message. Look, we completed the steps. We're ready to set a trial date. If the steps are not completed, then perhaps a judge could say, well, let's have an appearance, so you need to explain why this is not completed. It's very simple. We don't need to be going to court every 3 to 4 weeks and wasting time, and particularly during COVID, and particularly forever. This is something that should have been dealt with years before. And I can tell you this, there's certain jurisdictions in the states, including the federal court system, where they don't even have remand appearance. You don't need this reporting system. We're in the 21st century now. Let's report electronically and do the normal steps in the file. Steps in a file are not done in the courtroom. They're done outside of the courtroom. And I've had this critique for many years, and the COVID has really, really highlighted it for all of us in the justice system. So I hope the Ministry of the Attorney General does the right thing and gets rid of it, so we don't have to waste time every 3 to 4 weeks going to court.